Dry leases, management agreements, and the sham lease. Hello again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now, let's turn to the second major issue. How is operational control, how's it transferred, shared, or faked in the real world? The most common source of confusion is the dry lease. FAA guidance is clear on the basic rule. A dry lease provides the aircraft without crew, and the lessee normally exercises operational control. A wet lease provides the aircraft and at least one crew member, and the lessor normally exercises operational control. That distinction appears in FAA guidance and in 14 C.F.R. section 110.2, which defines a wet lease as an arrangement to provide an entire aircraft and at least one crew member. But that apparently clean distinction becomes messy very quickly in practice. The FAA has repeatedly said it will examine these arrangements case by case. In the Johnson legal interpretation, the agency stated that under a dry lease, operational control resides with the lessee, while under a wet lease, the lessor generally retains it. That same interpretation emphasizes a key consideration: whether the aircraft and crew are obtained separately or together as a package. This is exactly where many private aviation structures break down and fail. The FAA's more recent Mansour interpretation makes the point even more directly. The agency said it will look at whether the lessee truly assumed operational control and whether the parties acted in concert through a combination of transactions or dealings to furnish a leasing package that included both the aircraft and crew members. The FAA specifically pointed to who produces the pilots, who carries the liability for operations, who conducts maintenance, and who dispatches the aircraft. That is why the so-called sham dry lease is such a recurring problem. The FAA Safe Air Charter guidance warns that a sham dry lease or wet lease in disguise can occur when parties act together to provide both aircraft and crew, even if the passenger signs two separate documents. Separate signatures do not rescue a single commercial reality. This is where management agreements also become critical. A management company can provide valuable and lawful services: scheduling support, hangar coordination, maintenance oversight, accounting, insurance, administration, and charter management when the aircraft is placed on a certificate. But once the manager is effectively deciding who flies, when the aircraft flies, under what authority it flies, and whether the aircraft is available for a requested mission, the operational control analysis becomes highly fact-specific. Large aircraft leasing rules make the point concrete. Under 14 C.F.R. section 91.23, a qualifying lease must identify the federal aviation regulations under which the aircraft has been maintained and inspected during the prior 12 months. And it must identify the person responsible for operational control. That truth-in-leasing clause exists for a reason. The FAA knows that parties often become casual exactly where the law requires precision. There is also a common misunderstanding about Part 91, Subpart F. Section 91.501 allows certain non-common carriage operations for large turbine aircraft, including flights under time-sharing, interchange, and joint ownership arrangements. But those exceptions are not shortcuts around operational control. They are regulated pathways that still depend on the facts matching the rule. For example, in a true timesharing arrangement under Section 91.501, one party may lease the aircraft while the flight crew to another party and recover only the categories of charges allowed by the regulations. And that can be lawful. But if the parties start treating the arrangement like a public charter substitute, or if the aircraft is offered too broadly, or if the operational decisions are really being made by a management company that is packaging the aircraft and crew for others, the structure can drift towards common carriage and unauthorized charter. A simple but powerful example is this. When the principal calls for a flight, who has the right to say no? If the lessee can independently select qualified crew, independently decide whether to conduct the trip, independently bear the responsibility for compliance, and independently direct the flight under Part 91, the dry lease narrative becomes stronger. If the supposed lessee must use the owner's pilot, the owner's scheduler, the owner's maintenance gatekeeper, and the owner's dispatch process, the story really weakens fast. Another example to consider, who can replace the pilot? In a real dry lease, the lessee should have meaningful discretion to procure independent flight crew, subject to legitimate insurance and qualification standards. If the lessor or manager controls pilot selection and practice and the lessee has no realistic alternative, that is evidence the aircraft and crew are still being provided together. Here's a memorable point. A dry lease is not created by deleting the word crew. It is created by actually transferring control. From a structuring standpoint, that means the documents and the operating reality must line up. The lease should be executed correctly. The lessee should understand its regulatory responsibilities. Crew procurement should be genuinely independent. Dispatch authority should be clearly allocated. Insurance and indemnity provisions should be consistent with that allocation, and the invoices, email traffic, scheduling records, and trip approvals should all be consistent in narrative and tell the same story. Because in this area, the FAA does not just read the contract, it looks into the facts and circumstances of the operation. The bottom line is simple. Most operational control problems in private aviation are not caused by exotic legal theories. They are caused by ordinary business people using extraordinary aircraft under structures they don't fully understand. Thank you for your interest in this topic. This information has been provided for informational purposes only and should not be construed as legal advice. Questions are certainly welcome. Please direct those questions to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.